This is You and the Law on AM 650. Now back to the show.
And a good show it is today, too, here on This Is the Law. David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver back with us in studio. These gentlemen are with a firm that, own the firm that deals with wills and estates. And this morning we're talking about wills variation. And one of the key players in every will scenario, gentlemen, is the person known in law as the executor. The person, generally speaking, who had some kind of relationship with the person who wrote the will, who has been asked, will you be my executor? So, Ian, what is an executor in law?
An executor is the person appointed under a will to administer the estate. Now, until that person obtains probate of the will through the probate registry of the Supreme Court of British Columbia, they're not an executor. They're the proposed executor, so to speak.
Right.
And their job, usually they're chosen because they have some business acumen, perhaps a close relationship with the deceased. They could be a significant beneficiary under the will. Could be a child.
Oh, so that's not unusual for the executor to, in fact, be a recipient of some of the proceeds of the will.
Not at all.
Okay.
It can be because quite often an executor will be the spouse or child of the willmaker.
Okay.
And the executor's task is to bring in the assets of the estate, to pay the debts and liabilities, and to distribute the net estate to the beneficiaries in accordance with the terms of the will. All subject to a will's variation claim, however.
Okay. Now, David, the person who gets appointed to be the executor of any estate is usually asked to be that person. You're approached by a family member, or no, you gentlemen are both lawyers. Do lawyers impartially act as executors? And if so, do you charge?
Well, I agree with you that, and you're right, that I think in most circumstances the will maker will have made the executor aware that they have their permission to appoint them.
I'd like you to look after my affairs after I go.
Yeah, because it's a job, and it's a lot of work and a lot of stress in some situations. So it's not something you just want to dump on a person unannounced. Lawyers historically, for clients, would act as executors of estates. I think it's less frequent now because we live in a more litigious society. We're more concerned about independence and conflict of interest, and I think for the most part lawyers would tend to shy away from being the executor for a client and only do so if it was an unusual circumstance. Better off to have someone else let the lawyer be the lawyer, not be the lawyer and the executor.
Is there a test of any kinds? Do courts, for example, ever have issues with people who have been appointed executors as to their ability to do the job that they've been requested to do? Have you, in your travels, ever experienced an executor being rejected by a court?
Well, you can bring application to court to remove an executor, or who is an executor is a trustee and is under the Trustee Act, and you can apply to court to remove a trustee. That would be due to inaction, incompetence, bad behavior. It would have to be some circumstance that when proven, indicated it wasn't appropriate that that person continue administering that estate.
A good example of that, Sterling, might be an executor who received many gifts, apparent gifts from the will maker during the will maker's lifetime that the beneficiaries under the will want to challenge.
Oh.
We have cases, Sterling, where maybe a couple of adult children will come to see us. They'll be concerned about their mother's estate not apparently having any assets left. We'll discover that another child has made himself or herself the joint owner of the real estate or the joint owner of the bank accounts, and is also the executor of the will. And that executor maybe will say, well, I don't have the will or can't find the will, or I'm not going to bother administering this estate, there's no assets left, and so on. And that becomes a process where we ask the court to pass over that appointed executor to appoint someone else, and then we go back and look at all the transactions between that deceased person and that executor.
Now, that sounds like a process that might take longer than 6 months for even family members to figure out. again, going back to the statute of limitations on wills being 6 months in length, what happens if all of this stuff happens, David, and it takes a lot longer than 6 months for everybody involved in the will to figure out exactly how they've been, well, perhaps even conned by somebody who has a separate agenda apart from what the will maker intended?
I mean, quite often we have to go out and get court orders to cause banks or brokerage firms or other organizations to produce records and files to provide the documents to see when the joint tenancy was created or the joint account or whatever the nature of the investment was. And there's usually two situations. One is that maybe the will does have a fair and equal distribution between children, but there's nothing in the estate because one child has been busily positioning themselves.
Siphoning off funds, perhaps?
Another situation may be that it's not only the siphoning off of funds, but it isn't a fair distribution either. So you have a wills variation claim, plus you're attacking the transactions and trying to bring the gifts back into the estate. We call that a resulting trust. But so there can be many things going on, lots of documents, lots of information, and lots of digging, basically looking under stones.
And I'd like to add that the limitation period to investigate those sorts of transfers is much longer than the 6 months under the Wills Variation Act.
Okay.
So it's at least 6 years under the current regime, although there's a new limitation act coming in soon, which is going to turn a lot of limitation periods that were formerly 6 years into 2 years.
Okay.
But arguably, in this scenario, we might even be talking about a 10-year limitation period because we're talking potentially about a person who holds assets in trust for the estate, and some of the trustee causes of action have 10-year limitation periods.
So in a typical case, though, that is, the executor is appointed by the person who dies. The executor sees that all the ducks are in a row, so to speak, applies to the courts for permission to probate the will, to begin the formal process of executing the will. And how long, generally speaking, would it take for an executor to complete the process as he was or she was asked to by their friend that got them into this in the first place?
Well, from the date of death to the date of grant of probate, I would think that if you're looking at 4 to 6 months to get a grant of probate where there's no issues, I mean, you're able to move forward fairly promptly.
Okay.
Registry has lots of applications, takes them a long time to process them because of the volume of work and so on. But I think 6 months is an efficient period of time to estimate to get a grant of probate if no one's going to challenge that validity of the will or who the executor is. After that, depending on the complexity of the estate, the matter could go on for a year or two. In terms of looking under stones, getting documents, interviewing witnesses, talking to people to, in effect, reconstruct what's happened to that estate. So it would go on for a very long period of time. I would mention, though, that we find in estate litigation it's very amenable to mediation sometimes, which allows the parties to come together with their lawyers and with a mediator and to have a discussion about the concerns, try to get the facts out on the table and try to find a way of resolving the matter through negotiation, through mediation, and so on, as opposed to the formal process of court, which means you're going to have witnesses and a judge and appear in a courtroom and follow the formalities of that process.
And no negotiations possible. I think that would be the difference, right, Ian? If you go into some kind of mediation environment, there can be give and take on both sides of the table. But once this thing goes to court, there will be a ruling, and that will be that. End of story, right?
That's right. That's the benefit of either informal or mediated settlements is the parties control the outcome.
Is that preferable in most cases?
Well, it certainly is because going to court is very expensive. And at the end of the day, you're putting the decision into the hands of a third-party decision maker, a very learned one. But nonetheless, it's now out of your hands, and the chips are going to fall the way they fall.
I think we've seen situations where a will maker may have what I'll call outdated cultural or historical values, and so, for example, a person may decide they wish to leave their whole estate to their eldest son. They may have many children, and through a mediation process, children can speak to each other and say, is that really fair? Is it appropriate that this estate be distributed in this manner? They can share their views. It's very emotional.
Right, I'm sure.
But at least it gives them an environment to express their views and also to hear the other person's view. And that diffusion of emotion can sometimes help get problems resolved without formal court process.
I was going to say, and I'm glad you finally brought it up. I mean, this whole process, the work that you two do at Hobbs Giroday, I mean, there is an emotional quotient to all of this that hasn't been touched. You're the first person in this conversation, David, to even go there. And yet I suspect it's an enormous portion of how you have to deal with your clients. These people are angry, they're grieving, there's just a flood of emotions involved in almost every case you deal with, I'm sure, Ian.
Yeah, it's absolutely true, Stu. Sterling. It's kind of like family law that way, very high emotional content. And David's absolutely correct about the benefit of mediation in that context, because it's kind of a cathartic event where people get a chance to vent and to hear the other side. And, even where we don't end up with a settlement at the end of a mediation day, quite often the groundwork is laid for a settlement down the road.
Just enhances understanding all around the table, if nothing else, I guess, David.
Well, it's funny, in our business, I think sometimes the smallest things can be the biggest problems. So if one child ends up with a wedding dress that mom used to keep in their Chester drawer, and that may be very upsetting, it may create an impression that it was stolen. And you get people in a room and they say, well, I was supposed to get the wedding dress. They say, well, Mom said I was supposed to get the wedding dress. And, of course, one of the things we've learned over the years is sometimes elderly will makers tell different stories to different people because they just can't be honest with everyone.
Right.
And so they're trying to keep everybody happy.
And creating false expectations in the process.
Yeah. So, again, the mediation process sometimes allows people to have their say, hear what the other person has to say, and get a greater understanding of what the facts are and what the background is to the dispute. And sometimes that helps people find a solution. And that, in my mind, is just getting through the emotional stuff, understanding the truth, and then working from there, from a better base in terms of trying to resolve a problem.
David Hobbs and Ian Giroday are Hobbs Giroday in Vancouver, the law firm representing, well, many people in the matters of wills and estates. We're talking wills variation on this edition of You and the Law here on AM 650, and we'll be right back with more.
This is You and the Law. There's more of the show still ahead on AM 650.